right, so we've got appeals and cross appeals here. So first, let me ask the appellant, Mr. Kornberg, if you would like to reserve any time for rebuttal.
Yes, Your Honors. I'd like to reserve 5 minutes.
All right, and then Mr. McDonald, you're going to also have an opportunity to reserve time with respect to your cross appeal. So would you like to reserve any time? We can't hear you, Mr. McDonald.
You're muted.
I apologize, Your Honor. I'd like to reserve 2 or 3 minutes. I'll go as far as I can, but I'll reserve at least 2.
All right, so you folks will have to police your own time. I'll try to let you know. So the way it will work is Mr. Kornberg will go first, then Mr. McDonald for your main arguments, then Mr. Kornberg's rebuttal, and then Mr. McDonald's rebuttal. So go ahead, Mr. Kornberg, please begin.
Thank you. Good morning, Your Honors, and may it please the court. I represent Milestone Financial in this matter. Your Honor, this matter basically comes down to, one overriding issue, right? The California Constitution imposes certain usury limits for a loan or forbearance of money. The issue comes out here is whether or not the settlement agreement given by my client to the Moons after their default on the loan, which lowered the rate of interest, constitutes a usurious forbearance under the California Constitution. I think, if you look at the Moons' arguments, they really stress, their arguments come down to 2 things. And the first one is, well, the term forbearance seems to be well-defined in the case law, right? To quote Witkin from their own, that they cite in block quotes in their appeal brief, a forbearance is an agreement not to assist upon payment of the date of maturity of a debt or the giving of further time to pay. And they cite numerous other cases that say the same thing. Forbearance is an agreement to extend the maturity date of a debt or an obligation. Well, in DCM and in Gerardo, both cases, there was an obligation, call it what you want, time price, sale, or debt. There was a note identical basically to the note in this case, and it was extended. It arose out of purchase money sale by the
Let's not use purchase money sale. Let's use a credit transaction, sales credit transaction.
Yeah. The point is, okay, it was a credit transaction, but it was a note, right? Very identical to the one here.
Right, but I think the difference here, and we might as well jump right into it because I think you're absolutely right. This is the difference, is that transaction was between buyer and seller. It wasn't between a third-party financer. Isn't that, as Judge Montali found, the key difference here?
No. So to point out again, a forbearance is defined in California as an extension of the maturity date of a debt. Call a time price sale what you want. The debt's still mature.
But the whole point of Gerardo and DCM is that a forbearance in a transaction that is not subject to California's usury laws does not then trip over into the usury laws itself because the underlying transaction is not subject to the usury.
But how does that comport with DCM or Gerardo, Your Honor?
Because both of them are credit sales transactions that recognize that specific fact pattern and that those transactions are not subject to California's usury laws. Whereas broker transactions and forbearances, loans and forbearances, are specifically under the statute.
Your Honor, but the cases don't say that. Nothing in Gerardo...
Well, that's because Gerardo and DCM did not involve the broker exception.
Well, Your Honor, so I think going back to my original point, DCM described a forbearance, right? That the DCM court said, quote unquote, quoting the court, that the obligation at issue constituted a forbearance, right? And that it found that it was yet not exempt. And in fact, the court said this forbearance should be viewed in its own light, not out of which necessarily it arises. Each forbearance is its own loan transaction. Forbearance is in essence its own loan transaction. That is what the court said. So basically what that reading of the court statement is...
But again, let's go back to DCM, because then it says, we frankly admit that absent legislative direction or persuasive precedent, a factor underlying our conclusion that this transaction was not usurious, ... Isn't 1916 legislative direction?
It's legislative direction as to what a forbearance.
As to what is subject to the California usury laws,
I think
which
it's
has been upheld.
Well, no one's trying to overturn the usury laws here, Your Honor.
I don't know if that's right. I think by trying to impart Gerardo and DCM into the clear language as Judge Montali held in 1916.1, that seems to be exactly what you're doing.
I disagree, Your Honor, because the Gerardo court analysis does not hinge on that thing. How does the considerations of public policy, practicality, and all those items, how can this court not at least do that analysis, right? That both those cases required the court to go down and do 4 or 5 things on which basically have the exact identical outcome here. This court just wants to throw out that, basically 2/3 of the opinion just to read the top part and be done. That's not proper. This court can't impose its own interpretation, even if it thinks the DCM and Gerardo courts, should have just looked at the law, right? It has to do the analysis that the California courts did. And that analysis is the exact same one. It just arises out of a different exempt or non-usurious transaction. If you want to quote DCM, and I can, powerful reasons should exist before the law transmutes a legal transaction into an illegal one, particularly when the illegally places the entire financial benefit burden on one party and otherwise seems unjustly enriched. So let's go to this, right? What happens if this court is correct? Let's go back to the Moons. This court has already issued an opinion and Milestone files it. They go into default. Their loan interest, by the way, and I want to correct my record a little bit here. The loan has a default interest penalty, right? So Milestone would have had 2 options then. They could have just straight up foreclosed the second they defaulted because it cannot enter into a forbearance, or it could have waited to the maturity date of the loan, at which point the default interest would go up to 17.5% or 3%, under the note, right? So this benefits literally no one. The Moons interest rates go up. They don't get protected from the usury laws. They get a default interest rate, which is enforceable under established law. They don't get any security of knowing when their foreclosure will be. Milestone could foreclose immediately or it could foreclose later, but it couldn't pick up the phone and tell them any of that because anything of that would be an illegal forbearance, right? So they're not protected from
Picking up the phone would have been an illegal forbearance?
Well, if they pick up the phone and say, yeah, we will agree not to foreclose on you, right? That's a
Or they
forbearance.
could have agreed to a 10% interest rate.
They could have, but they're not going to.
And
Right?
I believe California law also requires consideration for
So-
forbearance. Isn't that what the case law says as well? So picking up the phone, you're stretching into a little bit of hyperbole. I understand the point you're trying to make, but I'm not sure that it's the strongest one.
But if it requires forbearance, Your Honor, they lowered the interest rate here. That was not the consideration for the loan.
Look, it seems like Milestone did what it could to try to protect itself, except to get the broker involved that was involved in the last one, or to reduce the rate. So,
Sorry, I apologize. Keep on interrupting you.
no, that's fair. I'm interrupting you, so no worries there. But
That is not correct. They could not bring the original broker back into this one. You can only do that if it arises out of a purchase money loan. This was a refinance.
okay, so you agree with that it never did arise out of a purchase money loan in your transaction.
Yeah, this is a refinance loan of an investment property. That is what Milestone's original one is, right? You claim this is hyperbole, but it's not, right? Where is the bright line rule, right? They can't give a forbearance, and unless they're willing to lower the rate of interest, right? So they can't lower the rate of interest. They have investors. They have promised rates of returns. Their only option is going to be to foreclose.
So, are you saying we should do equity to make a fair transaction and in so doing ignore the California statute regarding the broker exemption? Because I feel like that's what you're asking us to do.
I'm not asking you to do that, Your Honors, because that's not what
So
Gerardo.
how do you how does those two things go together?
I think, Your Honor, it's pretty simple. The forbearance, a usurious forbearance in the context of what DCM and Gerardo make pretty clear to me is that is when you take when you basically charge a usurious rate of interest as part of the forbearance, the consideration, so to speak, right? Here, that wasn't part of it. The consideration was a release of claims and a payment of a small sum of money, right? This is a very logical analysis, right? Why does this law protect borrowers? Does it protect borrowers from having the same rate from getting forbearance agreements, which doesn't increase the rate of interest but lowers it? I don't think so. What it does is it protects the borrowers from, basically having a loan and running out of money on a refinance loan, and then basically saying, and then the lender comes back and says, no, now I'm going to charge you a usurious rate of interest. You have to accept it, right? California does not allow that. Understandable, right? But this benefits no one. And the Gerardo cases, DCM says you have to take commercial considerations into this analysis. It's in the case law.
I think Bill says consumer as well, right? Because both DCM and Gerardo are both clear in their consumer protections. And this, by its terms, is a business loan, correct?
I've never heard of a world where the protections for are greater for the commercial borrower than the consumer borrower.
Right, but the representation is that this is not a consumer transaction.
Agreed, it is not.
Okay.
You're within your 5 minutes. Did you want to ask a question?
No, I do want to, yeah.
I'll reserve the remainder of it.
All right, very good. All right, Mr. McConnell. Mr. McDonald.
Thank you, Your Honor. John McDonald for the appellees, the Moons, and also for them on the cross appeal. The court has identified this very accurately. Quite simply, Milestone is completely wrong. The Court of Appeal, the Supreme Court in Gerardo specifically held, and they want to ignore the holding of Gerardo. And the holding is the usury law does not apply to this debt restructuring because there was no loan or forbearance. And they say, well, that's just at the top of the decision. No, at page 808, where they say, Section 5, the summary as to usury, quote, we hold the settlement notes were neither a loan or forbearance within the meaning of the usury law. They were instead the functional equivalent of the modification of a credit sale.
But let me cut the other way, because one of the strongest points that I think Milestone makes is the original transaction was above 10%, and it was not usurious pursuant to the code because of the inclusion of the broker. So why is that appropriate that a forbearance should be treated that? And your response is going to be because that's what 1916 says. But isn't there something that nags there that they are agreeing not to? You're basically saying they should have foreclosed, correct?
That would have been their option. The other option, as pointed out by the court, is they could have made the extension at a legal rate of interest.
Why would they do that? Why wouldn't they foreclose? So your client sought the forbearance, right? And they're going to say, no, we can't because we don't want to give you less interest. The risk, let's be honest, the risk is there's trouble paying, trouble before, the reason they got into this loan was because they had trouble paying the underlying obligation. So this is a fairly high-risk loan, repeated facing of foreclosure. So why would they reduce it? You are, as opposing counsel saying, forcing them to foreclose.
Well, foreclosures occur all the time. We know that they are part of the dealings in the
and bankruptcies to stop foreclosures happen all the time, and then we get these cases. Yeah.
Right. But the key point is, Your Honor, as you said, they want to basically argue that the Gerardo case accidentally repealed Section 1916-1, Subdivision 3. That provision expressly contemplates exactly what happened here. The original loan was made by a real estate broker in connection with the purchase of a sale, and the extension has to be made by the same loan, by the same broker, and the original loan must be in connection with the purchase or sale of a property. That's the statute. It was in place in 1983, and 11 years later, they claim that not knowingly, the Supreme Court repealed that statute. And the Supreme Court never even mentioned that statute because it has no application whatsoever in the Girardo case. Again,
But again, I appreciate your legal position because it's abundantly clear that that's your strongest argument. But I am troubled that there is the penalty here for forbearance in this situation.
yes. I'm not going to dispute that.
Okay.
And as I said, the legislature considered that problem, and the legislature made a policy decision that they will protect the borrower in that situation rather than protect the lender. And again, to come back 30 years later and say, well, we want the policy considerations that we like as a predatory lender to control over what the policy decision that the legislature
They're a
made.
predatory lender that your client chose to do business not with once, but twice, knowing their financial situation.
Well, as you pointed out, Your Honor, they were desperate both times.
Well, that's
Snapped the choice then.
that's desperate. But again, apparently this property has considerable value, and they could have sold the property, but that is not what they want to do. So, I mean, you're going to pay this lender through your plan, I assume.
Yeah, well, actually, Your Honor, as the lower court said, there's going to be a refinancing done. It should have been done last June, but we're still in the process of the Moons are refinancing, and they're going to pay the lender off.
Okay.
So again, the argument that basically Section 1916-1 Subdivision 3 should be repealed because it involves a situation where, in effect, the lender is forced into foreclosing. Well, what they're actually arguing is that every extension of every loan should be given the same protection that was given to the credit sale in Girardo. They want to extend the credit sale exemption, as the court, I think, has observed, and completely eliminate the application of the usury law to any extension of any loan, whether it involves a foreclosure or not. So that's the radical request that they are making, not based upon the holding of either DCM or the Girardo case, but expressly contrary to the holding of the Girardo case, that there was no forbearance in that case, and you can't call it a forbearance. So, at this point, Your Honor, I believe even Milestone recognizes that its position is untenable. At least when they wrote the initial brief, they could point to that one sentence in the Miller and Starr treatise saying, well, you could extend this logic and apply it to other loans, regular loans, as opposed to credit sales. Well, as we pointed out in our brief, Miller-Starr, in commenting on its own comments, said, well, wait a second, wouldn't that completely eliminate the application of the usury law to every extension or forbearance on a loan? And yes, it obviously would. So even Miller-Starr no longer supports them. They're out there just trying to twist some of the logic and valid arguments that were made in the case. They're trying to twist those into a complete repudiation of the usury law as it applies to any forbearance of any loan. So I think, quite simply, the law is clear. The law, and it's so clear that Judge Montali's analysis is absolutely correct. It's one sentence. DCM and Girardo don't apply because those are credit sale cases, and the credit sale exemption, which has been around for 170 years or so, as I pointed out in my brief, is completely different from a loan. A loan is the giving of money for an agreement to have it repaid. The sale of property is a sale, it is not a loan. And that's what Gerardo held, and that's what the court should follow. Moving for a second, I only have a few minutes here to move to our arguments on the cross appeal. The main argument we make is that Milestone is not entitled to any prejudgment interest because it breached the contract back in April of 2019 when it demanded excessive amounts far beyond what was legally owed under the contract. And the court has held the amounts that they demanded, one was an illegal 10% acceleration penalty, and the other amount was an illegal amount of interest. So Milestone doesn't dispute that none of the Epstein cases that have ever come up before any court involved a case where the lender breached the agreement. And this case does, so it's a completely different situation. Their only claim, which I believe makes no sense.
So are you saying that any time a lender files a proof of claim for a late fee that's later determined to be a penalty, that that's a breach of the agreement and they're not entitled to post-judgment interest?
No, I'm not saying that. That's a different situation. In the proof of claim is simply a claim of what they believe they're owed. In our situation, the borrower had a new lender ready, willing, and able to pay off the loan. And at that point, Milestone was obligated to deliver a proper demand, not one that's going to be adjudicated later in court, but a proper demand, and they didn't do so. So that's the breach of the contract at that point. There are obligations on both sides. The Moons were obligated to pay the loan, and they were trying to do that. And Milestone was obligated to give them a fair or reasonable payoff demand. And if they'd done that, they would have been paid off completely in 2019. And
You're within your
Other-
5 minutes, by the way.
right, I think I'll go down to 3. I got
Okay.
one more point to make here. Milestone also does not dispute the fact that the Epstein court pointed out that the award that they were giving is in the nature of damages when the borrower has wrongfully withheld the payment on the maturity date. But Milestone's not entitled to any damages because Milestone breached the contract. And they're not entitled to any damages, and the damages that they're looking at are prejudgment interest, which again is only damages calculated on the damages from the earlier date when there was a fixed and terminable amount. So if there's no entitlement to damage, they're not entitled to prejudgment interest on their damages. And finally, again, we put in that Milestone is not entitled to prosper or profit from its own misconduct. And at this point, I think I would like to reserve the remaining time.
All right, thank you. Mr. Kornberg?
Thanks, Your Honor. I would just like to go back to just the sort of earlier point, right? Let's just start really high level. There is no argument that the term forbearance covers what occurred by the factual definitions given by McDonald in his brief by every case, covered, technically speaking, what occurred in DCM and Gerardo, right? So there's no doubt about that. Just the court there basically determined that was not a forbearance for a variety of reasons, most of them doing equity, right? At the same time, Mr. McDonald, no one here has any defense for how this would better borrowers in any way except for the Moons. It would encourage foreclosures, it would cause higher rates of interest, and the Moons are the ones who sued Milestone to stop all those things from occurring after they defeated it, right? There's no argument here that this makes any sense except if you want to follow slavishly, just look at that statute and no other things. Now, I'm not saying that can't happen, but you read the GCM and Gerardo cases, I don't think you can come to the conclusion, looking at what the California court says, that you just look at the usury law and like almost like a civil thing and just do not interpret its use or purpose. And that in this case, again, you don't have to rewrite it. It's not a forbearance, a usurious forbearance, if it doesn't charge a usurious rate of interest. This forbearance didn't charge anything. It lowered the rate of interest. It could have kept it the same, for example. What it charged was another fee. So it gives a question, right? If you'd entered into a forbearance agreement, it didn't say the word interest. Would that have also been a usurious rate of interest if you just extended the loan? I think it's pretty easy to conclude that you have to go for the Gerardo and DCM analysis. You at least have to look at it, right? And if you do that, it's gonna apply. The court shouldn't come to a decision that benefits only the Moons and no one else. And no one has advanced any argument as how it would benefit anyone else. I'd just like to quickly turn to the cross appeal brief. I think that one is pretty simple. Mr. McDonald keeps on speaking of breach of contract. He filed a motion for summary judgment adjudication. Summary judgment adjudication in federal court allows you to bring it against claims or arguments or basically any piecemeal part of the case you want to within some limit. He listed 3 different things he wanted to adjudicate: the interest, the fee, and one other item. I'm sorry, I'm blanking off the top of my head. And none of which were a breach of contract claim. Milestone brought a summary judgment motion on the breach of contract claim. The court concluded that as to the default sending of a payoff statement, that was a disputed issue of material fact. Then the court said, Milestone, the Moons, are you willing to just live with the claims I granted summary judgment on or not? And they said yes and submitted a judgment to that effect. They've waived any breach of contract claim. It's done. And if there wasn't, it would have to be, it's done. They waived it. And they can't go back now. They may regret it, but so be it. The other point I'd like to make is California tender law is pretty clear. I don't think there is an exact case on the issue of, what constitutes a tender in the terms of a loan commitment letter. And I think that probably one could reasonably state that, to tender, you would have to provide a loan commitment letter that was no conditions except a payoff statement for X amount, right? At which Milestone would be on notice. I either accept this money, or if I'm wrong, I don't get interest. All they did was ask for 2 payoff statements. They cite to a bunch of things that they claim constituted, a tender letter, but provide no evidence that those were actually provided to Milestone. Further, none of them were. And I'd just like to point out that in the reply brief, Mr. McDonald filed on behalf of the Moons, he asserts that there was a final estimate that was essentially existed, not shown to the Moon, Milestone, that constituted essentially a payoff statement. That is, if you look at it, is on 221 of their appendix. It is titled a loan estimate under 12 CFR 1026.19E. That is given 3 days after a loan application is submitted. It is not anywhere close to a final statement. What he's talking about is the final disclosure on 1026.19F. There's no evidence one of those was ever provided to to the Moons, and that the Moons then provided it to Milestone. Thank you. I appreciate the court's time.
Right.
Unless there's any questions, 20 seconds.
No, thank you.
All right, thank you. Mr. McDonald?
Yes, Your Honor. I come back to this notion that the Moons waived their breach of contract claim. The entire record shows not only did they not waive it, they alleged it in their complaint. They sought breach of contract award in the motion for summary judgment. They prevailed on the claims in the complaint that Milestone breached the contract by making excessive demands on when it presented a demand in April of 2019. And finally, conclusively, the judgment holds that that the Moons prevail on the second cause of action. They're awarded judgment on the second cause of action for breach of contract. So the breach of contract claim was won, and we got an attorney fee award on it, and it was certainly not waived. And without that waiver argument, they have no real argument against the position on the cross appeal that Milestone is simply not entitled to any continued damages after the maturity date of the loan because they breached the loan back in April. So the next thing that Mr. Kornberg raised was that the tender wasn't proper. Well, what they actually said in their motions was that we didn't present any evidence that there was a proper tender. But in fact, the Moons submit, as I pointed out at page 9 and 10 of the reply brief, the Moons submitted a declaration just saying that they were ready, willing, and able to pay off. They had alternative financing. They provided the formal loan estimate of that. And then, as I pointed out in the brief and referred to Exhibit I, that document is not the initial loan estimate. That's the final estimate. They don't give that 3 days after they make the proposal. That's the final estimate they have to give 3 days before the closing. So that's there to give the borrower full protection that they have a loan commitment for that amount, and they can go shop around and see if they can get a better deal. And so the tender was perfectly complete, and all of the evidence shows that the Moons tried to pay it off in April, and they were ready, willing, and able to pay it off in April. And remember, they offered to pay it off in July, and that was rejected. We said, let's just pick a number and settle on that number. And they said, no, we're not even going to talk about it. And then finally, they also didn't take the opportunity to get paid off in a bankruptcy motion. So I think that part of the court decision should be affirmed. On the other part, I do believe the court should slavishly follow the law, because courts should follow the law.
Your Honors, can I just have 20 seconds to point out that one argument that was only addressed in his reply brief regarding the loan estimate?
Any objection? All right, 20 seconds.
Yes, Your Honor, again, page 221 of the Moons brief, which they cite as the final document, it says loan estimate on it, and then in the upper right-hand corner it says, save this loan estimate to compare with your closing disclosure. Whatever they think that they sent, what they attached is a loan estimate sent 3 days after the application was issued. Thank you, Your Honor.
All right, thank you. All right, thank you for your good arguments. This matter is submitted. Madam
Thank you,
Clerk?
Your Honor.
Thank you. Madam Clerk, can you please call the next case?